it's a decision of the Unified Patent Court, the UPC, here in our case, the Mannheim Local Division. It is a dispute between Fujifilm on the claimant's side here and Kodak as the defendant. We have seen previously also one decision regarding this case in our webinars, a decision of the local division of Düsseldorf. What we had mentioned then, and I'd like to highlight also today, is that this is not a SEP and front case. So the patent the patents that are being discussed here are not SEPs. However, as I said already, because we have a very important topic here, the long arm jurisdiction, the decision of the court is also relevant for SEP cases because this can be transferred also in the SEP front context. So what the court has decided here, or what the court has provided as guidance here, is also relevant for SEPs. Now here, very quickly, just to understand the setting, the case started back in 2023. Fujifilm filed infringement actions against Kodak in different local divisions of the UPC. We had cases before the local division in Düsseldorf and cases before the local division in Mannheim. And these proceedings moved with a different pace. The decision that was delivered first was the decision in Düsseldorf. Maybe before going that, what is also interesting here to mention, because it is basically the key aspect when it comes to the long arm jurisdiction discussion, is that the patents that Fujifilm had asserted here were, of course, a European patent that was with a uniform effect, unitary effect, that was then asserted before the UPC, but also the English designation of the same European patent. So the actions were directed not only to the infringement of a unitary patent, but also to the infringement of a patent that is in force in the UK. And as we all know, the UK is not a member of the EU and also not a member of the UPC agreement. So we had this extraterritorial aspect here exactly through this, through the assertion of claims that were linked to a UK patent. As I mentioned before, the first decision was delivered by the local division in Düsseldorf. That was in January 2025. And there, the court dismissed the infringement action because it questioned the validity of the patent. However, what was interesting in that case was that the court confirmed its jurisdiction regarding also the UK part of the dispute. So although the action was dismissed, the court said that it would have also decided about the infringement part that referred to the UK. Now, shortly after this decision was delivered, we had a very important development, not in these proceedings, but also affecting very much these proceedings as well. It was the decision of the Court of Justice of the EU that was delivered in February 2025 in a case called BSH versus Electrolux. And in that decision, the Court of Justice of the EU established the long-arm jurisdiction of European courts, national courts, but also the UPC that is bound to the CGEU case law and the decision of the CGEU. Again, long-arm jurisdiction means that a court in Europe, a national court like a German court, like the Munich court we discussed before, and or the UPC can assume jurisdiction about the infringement of patents that have been granted in another jurisdiction, in foreign jurisdictions. Now, after that decision was delivered, the Mannheim local division decided to split the case that it had before it. In April 2025, it delivered a decision regarding the German part, so regarding the infringement in Germany, and decided to delay a bit the decision regarding the UK part, which raised all of these questions regarding the long-arm jurisdiction, to give parties the opportunity to basically take a position on the CGU's decision in BSH versus Electrolux. That actually happened, and the decision of the local division in Mannheim on the UK part followed 3 months later in July 2025. And it was a decision which was positive for the claimant in the sense that the court granted also measures including an injunction for the infringement in the UK. Almost at the same time, the claimant asked the court to issue an enforcement order concerning the German part of the decision. In the view of the claimant of Fujifilm, Kodak had not complied with the decision of the UPC regarding the German part, and therefore asked the court to impose measures, to impose, for example, penalties for Kodak to basically comply with this decision. And after this decision was then delivered by the court in Mannheim, Fujifilm also asked the second time for enforcement measures concerning the German part of the dispute again. This was a motion that was filed in January 2026 because the claimant was still of the opinion that there was no full compliance with the UPC decision concerning the German part. So with this decision here from the 30th of January, the court delivered its decision regarding the second application for enforcement measures of the claimant. Just here, a brief note that this refers still to the enforcement of the decision for the German part. But as we're going to see, there are some links to the potential enforcement in the UK, so that moved the court here to also give guidance regarding this aspect, although it was formally not really part of these proceedings. Where we stand now, maybe just a brief update. There are proceedings before the Court of Appeal of the UPC regarding also the discussion around the long-arm jurisdiction. So we're going to see how this case evolves further and, of course, report when we have new developments here. Now let's see what the court said about the long-arm jurisdiction in the proceedings here. Maybe before we go into the details, again, here the general setting. So what we're talking about here, what is the long-arm jurisdiction? What are the questions that we need to address? Here we had said the infringement action had two patents, a unitary patent, which dealt with infringement in Germany. Insofar, the jurisdiction of the UPC was not really contested, it was clear. But the problem is how to deal with the UK patent, because as we said, UK is not a UPC member state, and at least it's not definitely clear whether the UPC can exercise jurisdiction on that. The answer to that question, as I mentioned already, was provided by the Court of Justice of the EU in the BSH Electrolux case. And just very quickly here, a brief reminder, what was the idea of the Court of Justice of the EU, what was the reasoning. There was an instrument that is applicable in Europe, in the EU, which is the so-called Brussels I regulation, which gives rules, provides rules of how the different national courts of the member states of the European Union should split the cases between them, basically, or which national court should take jurisdiction when you have cases that involve more than one member states of the EU. And here you have the fundamental principle in Article 4 that it is the defendant's domicile. So the courts basically where the defendant, so not the claimant, the defendant, where the defendant is based, should have jurisdiction. There are exceptions from that principle, which are called exclusive jurisdictions, where courts of a specific member states and only those courts shall deal with a specific type of cases. And for us, interesting is Article 24(4) of the Brussels I regulation, because there you have an exclusive jurisdiction concerning patents. Here you have the jurisdiction of the courts in which the patent has been granted, exclusive jurisdiction, so meaning that only this court can deal with respective cases. But these are only cases which refer to the registration or validity of patents. And if we want to summarize the decision of the Court of Justice in a nutshell, this meant that infringement is not covered by that. So infringement can be decided by the court where the defendant is domiciled. And in our case here, it was the UPC, because Kodak was based basically in Germany, so within the UPC territory. So this was the question here. And how to deal with the long-arm jurisdiction based on the decision of the Court of Justice of the EU. Now, in the present case, as I mentioned already, we did not have to deal directly with the enforcement of the UPC injunction in the UK, because we're still dealing with the enforcement of the German part of the decision of the UPC. However, the court said that although we don't have a request for the enforcement of the UK injunction yet, such request is very likely to follow. So it found that it would be a good opportunity to provide guidance of how to deal with these questions, also on the enforcement level in this decision here. And maybe one motivation was, apart from, let's say, giving guidance to the parties in these proceedings here, to provide a little bit broader guidance, because the Mannheim local division said here that the guidance they provide also seeks to de-escalate the current jurisdictional conflict, which means basically tensions that we have seen emerging between particularly the UK and the German courts and the UPC, of course, on the other side, when it comes to so-called interim license declarations that the UK courts have started granting in the last couple of years, and countermeasures that the UPC and the German courts particularly have taken to protect their proceedings against this type of interim license declarations. So the court wanted to provide also guidance that could be helpful to de-escalate this jurisdictional conflict, and added here that if we're talking about jurisdiction, the only basis has to be the applicable law. What the courts should not do when it comes to jurisdiction is to focus on concerns how their decision may be received by the interested circles, and whether or not they will be motivated by the decision to bring further cases to this court or in any other appropriate forum. So the court made clear here, when we're talking about long arm and we're talking about all of these situations where you could have multiple jurisdictions being involved and questions of comity and respect of the jurisdiction of other courts, foreign courts, are raised, the only thing that you should look at, according to the UPC, is the applicable law, and not whether you would take decisions in a way that would maybe motivate further cases to be filed in the same before the same court. So that was a more general comment of the court here, but I think it's also interesting to note here, because you give a bit of an insight on the motivation of the court to provide guidance here on the long-arm jurisdiction. More specifically, however, what the court pointed out, and I think this is the heart of the decision here, is that the question of international jurisdiction, including the long-arm jurisdiction, shall be strictly differentiated from the enforceability of decisions, especially also the enforceability of UPC decisions in foreign territories. So here, the court wanted to go a step further in this long-arm jurisdiction debate, and not only deal with the aspect of whether the court should at all take up a case which has this link to a foreign patent, to a foreign jurisdiction, but also to give some guidance of how to deal with decisions that might have been granted by the UPC or other courts when they have assumed jurisdiction based on this long-arm doctrine. And it made this clarification here that when we're talking about UPC decisions, it is clear that within the UPC territory, they are directly enforceable. So you can, if there is no compliance, you can take measures, ask the UPC to take measures to order and to make sure that there is compliance with a decision. So there is no recognition needed. This applies, for example, in our case here, regarding the first part of the decision of the UPC concerning the situation in Germany and measures in Germany. So insofar, the court said clearly, we don't need to take an additional step. The decision of the UPC is more or less the same as a decision of a national court. When it is granted within the territory of that court, it's directly enforceable. So there is no question about that. However, when you talk about foreign territories and the enforcement of a UPC decision in foreign territories, the decision must be recognized by the competent national court. So in that case, you have an additional step you need to take. You cannot go and enforce this decision without basically asking the national courts in the jurisdiction where you seek to have enforcement whether they are more or less okay with that decision, whether they recognize that decision or not. There are some exceptions of this requirement to have a foreign decision recognized in another country, which can be based on bilateral or multilateral treaties, or even the Brussels I regulation we mentioned before. Indeed, within the European Union, the Brussels I regulation has a more streamlined procedure for the enforcement of decisions of national courts within the EU. But here, in the present case, when it comes to the UK, the court did not see any of that type of bilateral or multilateral treaties being applicable. So that meant that since no such treaty exists, a UPC decision is enforceable only after it has been recognized by the competent national court in accordance with a national principle to be applied. That said, the court clarified here that any measures, any requests to the UPC to look at the enforcement of the decision and to basically take enforcement measures either directly or indirectly, as we're going to see in a moment, before the recognition is there, would be premature. So the UPC would not be willing to take enforcement measures for a decision that it has granted that has an impact above or abroad that refers to a patent, a foreign patent, before the decision has been recognized by the courts in the respective country. And the court made clear that this principle is generally applicable. So it's applicable with no difference if the case concerns an SEP or any other patent. It's applicable to every type of remedies that the UPC might grant with a link to the foreign jurisdiction, so injunctions, but also other remedies. And it refers to direct and indirect enforcement measures. So direct meaning orders for a shutdown of production plants, etc., but also indirect enforcement measures like monetary penalties that the UPC could impose on the defendant if he has not complied with the case, with the injunction, for example, or any other measures in the foreign territory. There is one exception from that principle, which the UPC also highlighted here. And this is an exception when the effects of the enforcement would not affect the foreign territory. And the court mentioned one example here, a claim for rendering information, for example, that concern use or activities in non-UPC territories would not be falling under this principle when the damages in the foreign territory are based on infringement within the UPC land. To be more precise, if you had here in the present case infringing actions being taken in Germany, so manufacturing particularly of the infringing products in Germany, then if you would like to have also information about the sales of the infringing products that have been exported to the UK, there you could take enforcement measures, even if this would be talking about or this would be affecting activities outside of UPC territory, because otherwise it would be very difficult to enforce a decision in Germany, and it would be very difficult also it would be very easy to circumvent measures taken within UPC territory. But apart from this exception, generally the principle is that the UPC is going to start enforcement and take enforcement measures based on a decision it has granted that is applicable or has effects in a third jurisdiction, in another jurisdiction, in our case in the UK, for example, only after the decision has been recognized abroad. I think this is important here to keep in mind, because in the broader debate around the long arm jurisdiction and its effects, I think it gives a good indication of where the UPC draws some boundaries. And this can, of course, if this case law is being confirmed, will be confirmed further on in the future, give more clarity around the boundaries of the long arm jurisdiction, especially also from the perspective of what to do, or what, let's say, the value of decisions would be that the UPC or other national courts in Europe will grant based on this long arm jurisdiction.